The strongest bonds of silence in the law are held in the attorney-client confidentiality privilege. But not every communication with an attorney rises to the level of a privileged communication. These videos, for example, are an attorney speaking with you who came to watch the video, but none of this is privileged. Hi, I'm Jack Razmich with Razmich Associates, and today we're going to talk about the attorney-client privilege and how it actually works. The attorney-client privilege is an evidentiary rule that protects confidentiality of certain oral or written communications between a lawyer and his client. The rule prevents attorneys from revealing the content of those protected communications to any third party. The purpose of the privilege is to encourage candid and honest communication between the clients and their attorneys. It permits clients to speak freely without fearing that a court will compel their lawyer to testify about the information they've shared, or that the opposing party will seek this information in a discovery request. On the other hand, it makes lawyers more likely to obtain the client's full story and provide the best possible legal advice based on the information that they are given. So when does the attorney-client privilege apply? Not every communication between a lawyer and a client is considered to be a protected communication. For the privilege to exist, the communications between an attorney and a client must be 1. Made for the purposes of obtaining or giving legal advice, and 2. Intended to be confidential. Although that might seem like a very straightforward and simple rule, both the client and the attorney have to be careful that they are not inadvertently waiving any privileges. So how do you maintain the attorney-client privilege? Well, to maintain the privilege, both you and your attorney need to take steps to ensure that no one outside of members of the legal team hears or reads any protected communications, whether intentionally or accidentally. You might be tempted to discuss your attorney communication exchanges with a third party, such as a parent or a spouse or another loved one, but this act does technically jeopardize the privilege. Even if you speak with your attorney in a public space and a third party overhears that conversation, you could potentially waive the privilege of attorney-client confidentiality. If a court finds that you have waived your privileges by disclosing the communication to a third party, it might actually compel that third party to testify about the content of those communications. So, how do you ensure that your attorney-client communications are properly protected? Well, there are 4 very simple ways. First, never share your communications with your attorney to other people. 2, maintain a written communication with your attorney in a secure location that third parties can't access. Use a password to protect any digital communications like emails. 3, when sending written communications, ensure that they're going to the correct physical location or email address. And 4, don't speak with your lawyer about legal matters within earshot of third parties or other potential eavesdroppers. Please be aware that you, as the client, own this attorney-client confidentiality privilege. You have the right to break this privilege intentionally. Your attorney, however, does not have that privilege, and anything said to him must remain in confidence. There is only one real exception to that, which is that the attorney can break the privilege only if the client has expressed an intention to commit a crime or fraud, or is otherwise required to disclose those communications under the Indiana rules of professional conduct. Fortunately, those situations are few and far between, and you can rest easy that any communications you make to your attorney are in fact confidential. A very common question that I receive at the beginning of every case evaluation is whether or not anything they say to me is going to be held in confidence. The good news is, at a case evaluation, the communication made to my office is for the purposes of obtaining legal representation and legal advice, so you can rest assured that any communication made to our office during a case evaluation is absolutely 100% positively confidential and secure and kept within that privilege. So that being said, if you or a loved one has a legal issue that needs to be addressed, but you have been worried that anything you say to the attorney is going to get out, rest assured here at Razmich Associates, that is never going to happen. So, again, please consider giving us a call if you have an issue that we can address for you. The telephone number here at this office is 317-983-5333. That number will get you your free and confidential case evaluation. Case evaluations are free, they always will be, and they have always and will always remain confidential. You lose nothing by asking for our office to help provide you with advice. We are happy to do it. That number again, 317-983-5333, and I look forward to the opportunity to speak with you. If you like this video, please remember to like and subscribe. If you really like this video, please consider sharing it on the social media platform of your choice. Here at Razumich & Associates, we are lawyers ready to fight. The more eyes that we're in front of, the more people we're fighting for. The more people we're fighting for, the freer society as a whole becomes. If you have a question or a comment or a question about a video that you might like to see in the future, please consider dropping it in the comment section below. We do read those, we do review them, and we even do respond to them. Thanks for watching, and I'll look forward to seeing you next time.